Hi, my name is Sue Rogers. Thank you for joining me today. Today we are going to discuss the Dram Shop Act and criminal liability. The title of my presentation is Wait, Should You Serve Another? By the end of this presentation, I would hope that you would be able to describe the history and the evolution of the alcohol law, be able to define the Dram Shop Act, be able to identify states enacting the Dram Shop Act, identify the legal elements and liabilities of businesses, and be able to describe cases and verdicts of the Dram Shop Act. So here are a few facts that I found interesting. This was from 2017 from the National Safety Council, and they estimated that 40,000 people lost their lives to car crashes, and 4.5 million people were seriously injured. Now that doesn't account if these were alcohol-related incidences. And another fun fact is that in the 19th century, there were laws already being created that would protect the public from intoxicated people. Here is a little timeline of the history of the law creation. So, in the 19th century, starting in 1803, there was the first published cocktail that was ever made. In 1811, the first planted vineyard in Canada. In 1818, a temperance society was formed in 20 countries, and this included the United States. And that was a major event in the 19th century, the creation of the Temperance Society. It was a group of people who demanded prohibition of alcohol, and they also wanted to promote moderate use. In 1825, sparkling wine started to get produced. In 1838, Maine passed the 15-gallon law, and what that law meant was that you could only purchase 15 gallons of alcohol per person, and that was it, minimum. In 1849, the term alcoholism as a disease is published by Magnus Huss, a Swedish physician. In 1869, Prohibition Party was formed in the United States, which meant that the law or regulation was created for alcohol. In 1872, the United Kingdom passes their Licensing Act, restricting the hours of alcohol sales. In 1880, several U.S. states adopted a statewide prohibition of alcohol. In 1984, New Zealand placed restriction on hours of selling of alcohol. And starting from this point on in the early 19th century, more and more countries started developing laws specific for alcohol, distribution, hours, and selling contents limits. As laws started to develop over time for alcohol, prior to the 1970s, the common law negligence was enacted. What this meant was it was the responsibility was solely placed on the drinker, and the server was viewed as playing an irrelevant role and relieved of any legal responsibilities. As the years went on, in the 1970s, citizens started to create a movement to prevent drinking and driving, and state courts started to realize that the old common law rule needed some revamping. So what they added to that was drinkers' actions are the sole proximate cause of any crash or damage. Again, a few years roll on, and now the criminal liability statute is enacted. Within that statute is created the Dram Shop Act. The Dram Shop Act has two types of laws: the first party dram shop case and the third party dram shop case. So basically what the dram shop main function is is to stop serving drunk people alcohol and even try to prevent customers from driving after they leave the premises. Now, within this dram shop law, either the intoxicated person can be liable or the distribution of liquor, which is the server or the place of distribution, can be liable. So let's define Dram Shop Act. What is it? It's a body of laws governing bars, taverns, liquor stores, and other establishments selling alcoholic beverages, and it makes them liable for serving alcohol to visibly intoxicated person and/or a minor. This law also governs civil liability damages, injuries, and deaths caused by individuals who are overserved. How did the Dram Shop Act get its name? Well, in the 18th century, when people used to go buy spritz, they were sold in what was called a dram, and it's a measure of a unit, and these shops were known as dram shops. So under the Dram Shop Act, as of 2019, there are 43 states, plus the District of Columbia, that enact the law. Dram shop laws are not the same from state to state. They all have their own characteristics. However, there is one commonality in the law that you will find, which is the wording obvious intoxication tests, where the retailer knew or should have known the patron was intoxicated. There are 8 states that do not enact the dram shop law. They're Delaware, Kansas, Louisiana, Nevada, South Dakota, Virginia, Maryland, and Nebraska. These states do not allow third-party victims to sue licensed establishments. So I'm from New Mexico, and I kind of wanted to focus on New Mexico Dram Shop Act. So in 1982, there was a case of Lopez versus Mays, and during this case, the Supreme Court recognized for the first time that a third party who was injured by an intoxicated driver had a cause of action against the tavern keeper who illegally served alcohol to the intoxicated driver. Now, there was no enactment at that point or law, so in 1983, they added Section 41-11-1, which meant a person may be subject to liability if he or she breaches his or her duty by violating a statute or regulation. 2 years later, in 1985, Section 41-11-1 was amended, and it included the right for an injured patron to collect damages and obtain relief. So basically, that was the Dram Shop Act, started to be enacted in 1985 under New Mexico law. In 1993, this is just a little info, New Mexico legislature amended that all persons that serve alcohol must take a mandatory responsible beverage service training. This helps them identify when to stop serving patrons who may look intoxicated, and it also educates them on any liabilities that they may have. Dram Shop Act. Mothers Against Drunk Driving have been huge advocates for the law. Within the United States, Canada, United Kingdom, New Zealand, and Australia, they have pushed for this law to be enacted. Mother Against Drunk Driving has data that shows when countries or states enact the law, it reduces alcohol-related crashes by 3 to 5%. In addition to that, it increases public awareness and educates people on the liability of servers and managers. And lastly, it decreases inaccess and illegal consumption through lower drinking prices that we commonly see in happy hours. So happy hours, they're usually about 2 to 3 hours, Well, studies have shown that with the decrease in happy hour hours, it shows that drinking is decreased by 1.6 drinks on average. Well, who is liable under the Dram Shop Act, and how do you determine liability? Well, liability is defined as the civil liability faced by both commercial servers and social hosts for the injuries or damages caused by their intoxicated or underage patrons or guests. You have to prove liability if you can prove sale of alcohol to the patron, or you can prove injuries were sustained by the patron, or number 3, proximate cause between alcohol sale and intoxication, and 4, intoxication was at least one cause of the third-party damage. What types of licensed businesses are liable? Well, you have your restaurants, your casinos, your casino boats. We don't have any in New Mexico. Bars, breweries, liquor stores, and any vendor that sells alcohol. So in addition to the Dram Shop Act, some states have created a complementary policy called the Social Host Liability Law. Basically what this is it imposes liability on social hosts and non-commercial establishments and can assign criminal or civil liability. So for example, if you're hosting a social event at your house, maybe a baby shower or a bridal party or just a birthday party, and you're serving alcohol, and one of your guests drives home drunk, and it was proved that you were the one who gave them the alcohol even though they were intoxicated, you can fall under this social host liability law. So here are a few cases that fell under the Dram Shop Act. 3 of them are here in New Mexico. The first case is Ruiz versus Applebee's in Bluecorn. This was in 2010. Applebee's was found they didn't break the law or violate the state's Liquor Control Act. However, Bluecorn did settle claims with the family that was involved because Mr. Ruiz entered the Bluecorn Cafe after he left Applebee's, where he continued to drink, and he was obviously intoxicated when he arrived. So therefore, Bluecorn was held liable in this case. After the case, Bluecorn did impose new limits on customers on how much they can drink. The second case is Mendoza versus Tamaya Enterprises, and this was in 2006, again here in New Mexico. In this case, the plaintiff's family was trying to hold Tamaya liable for their one vehicle accident. So the Mendoza couple had went to a wedding at the Tamaya and had left there intoxicated. And when they left, they got into a one vehicle car collision, a rollover, and the family died, or the couple passed away. In this case, Tamaya was not found liable under the Dram Shop Act. The third case is the Dana Paps versus the U.S. Airway, and in this case again, based on the evidence or proof provided, U.S. Airways was not found liable on this case in 2002. And another case just to mention is Reed versus Brenton. This was in Michigan in 2001. In this case, Brenton was found non-liable under the Dram Shop Act. These are the references that I used for my presentation. This concludes my presentation, and thank you for taking the time to meet with me, and have a good day.